If I can go straight on now to you, Alex. Alex Layton, two from me, is a practicing barrister, 20 Essex Street, a silk, a wide range of commercial and other disputes. He's the joint general editor of European Civil Practice, visiting professor at King's College in London. He's also a fellow of the Chartered Institute of Arbitrators and a past chairman of trustees of the much admired British Institute of International and Comparative Law. Alex, over to you.
Thank you very much, Tony. And thank you very much also to the organisers. I'm very sorry that my professional commitments have prevented me being at much of the conference so far, and it's being made very plain to me how much I've missed. So I'm sorry about that. Having said that, with some degree of trepidation, I'm speaking to you today because I came in at the end of Gary Bourne's talk, where he was reaching something of a peroration, extolling the virtues of international arbitration over all forms of court-based dispute resolution. And here we are talking about court-based dispute resolution, but it's the hardy few who have stayed for this part. My build topic is to look at the jurisdictional basis adopted by common law tradition, small states, and questions of recognition and enforcement, and compare them with the 2005 Hague Choice of Court Convention. And I propose to do that briefly, but I'd do it fairly loosely. I don't really have a sense how many of you come from common law jurisdictions as distinct from jurisdictions that have a different tradition, whether civilian or not. Somebody, if you come from the common law traditions, will you put your hands up, please? So I've got some idea. Well, you're mostly common lawyers, so most of what I have to say to you will be meat and drink to you anyway. Let me just, therefore, sketch it in fairly lightly. The three particular jurisdictions where which I've looked at, and in two of which I've had experience as counsel, admitted for the individual cases, as Barbara said, are the Cayman Islands and Bermuda, which of course neither of them independent states as such, but they are separate jurisdictions. And I also wanted to look at the Supreme Court of the Eastern Caribbean, which brings together 6 states and 3 territories under a single jurisdictional basis. So we heard earlier about the cooperation involved in the Caribbean Court of Justice, and this is another example of small states pooling their resources and their expertise to found a regional court. And it's very interesting that that is one form of capacity building that is going on in the Caribbean at all events. There are other steps being taken to build commercial dispute resolution capacity. There's now a commercial division of the Supreme Court in Bermuda. There's a financial list in the Cayman Islands. I don't know if there are lawyers here from either of those jurisdictions, and in which case you can correct me if I got it wrong. And there is definitely an attempt to have judges of sufficient experience and quality to deal with the advanced commercial cases that very often will arise, not just at the hands of Mossack Fonseca, but at the, with the input of good and experienced lawyers in those jurisdictions. So we're familiar, aren't we, with the traditional bases of jurisdiction in common law systems. So far as assertion of jurisdiction over persons present within the territory is concerned, that's based on service. I was very interested to hear the comments from Justice Anderson on what constitutes a presence for a company for the purposes of the exercise of jurisdiction. And there will, of course, be nuances of difference between these different jurisdictions as to what they treat as presence for these purposes. And that then is, of course, in all these jurisdictions that I've mentioned, and no doubt others as well, subject to the forum non conveniens power to stay. It's a creature that within the professional lifetime of at least the 3 of us here has come to be taken as axiomatic, although it didn't exist by the time any of us started. And it is one of those things that once you have it, you wonder how you ever did without it. So too, another example is the freezing injunction, formerly known as the Morava injunction. We didn't have them. It started in 75. And it started in 75 in a case not called Morava, but called Cara Georgis. Michael Carr, the late Michael Carr, urged people not to call it a Cara Georgis injunction because it would never catch on. And so they called it a Morava injunction instead after the second case that came called. So, as I say, that's the assertion of jurisdiction over persons within the territory, relatively straightforward. And then we have the rules that today reside in the glorious location of paragraph 3 of Practice Direction 6b to the Civil Procedure Rules, but are known everywhere else, or many other places, as Order 11, known to all of us as Order 11. And they started their proud history in the Common Law Procedure Act 1852, but they've had a downhill journey ever since. And those rules are largely modelled, as far as my researchers have been able to show, on the 1999 version of our rules of the Supreme Court. They haven't, by and large, kept pace with the changes that have occurred here since we introduced our new civil procedure rules. But there are some points of difference, and I will take you to one or two of them in a moment. You'll recall that there's a relatively limited statutory basis for what you do, and then there's a panoply of case law on top of it. And this case law has not been completely uniform in its transposition from one jurisdiction to another, although I think there's probably, it's fair to say, maybe Justice Sanderson will have a better appreciation of this than I do. There's been a general trend, and some of the developments that have occurred here have been followed in other common law jurisdictions in this regard. So, for example, we know, first of all, that you have to bring your case within one of the gateways, one of the sub-paragraphs in what I will call for shorthand Order 11, and that you then have to show that the case is a proper one for service out of the jurisdiction, which itself carries an awful lot of law within that short proposition. It carries really three propositions. It carries the proposition that the plaintiff must show a real prospect of success. That's to say, real as distinct from fanciful. Doesn't have to show that he's going to win. He has to show a good arguable case, that the case falls within one of the gateways. So he doesn't actually have to establish that, for example, there was a breach of contract. He merely has to show a good arguable case to the effect that there was a breach within the jurisdiction of the contract or something of that sort. And thirdly, he has to show that the forum is appropriate. He has to be clearly or distinctly the appropriate forum. And those thresholds, lip service is paid to how difficult they are to get over, though in reality, certainly my experience in the commercial court is it's surely easier to get over them at the ex parte stage. There may be more of a battle at the inter partes stage. And once you've done that, you then end up with the person who would not otherwise be subject to the jurisdiction being brought before the court of the relevant territory. Now, one interesting point is that there has been, as we know, ever since the Siskina, a debate in England about whether a claim for an injunction alone can found permission to serve process out of the territory. And Lord Diplock was understood as saying that that was not possible. The Privy Council, then Mercedes-Benz and Leiduk reiterated that in respect, I think, of Hong Kong. It's been statutorily relaxed here by allowing interlocutory relief to be granted in aid of process in other jurisdictions. And that development, I've noted, has been adopted, for example, in the Cayman Islands, a case called VTB and Universal Telecom. It was a spin-off of the VTB and Nutritech case that went to the Supreme Court here. It was held that that the grant of a freezing injunction in aid of proceedings in another jurisdiction was permissible in Cayman, in aid of a right which was being pursued elsewhere, subject to a number of criteria, such as that the underlying cause of action is one which was being pursued in a jurisdiction, the judgments of which would be susceptible to recognition and enforcement in Cayman. And it was based on what's been called the Chabra injunction, whereby you bring an application for freezing order or a waiver injunction against a party who is not themselves the target of your cause of action, but is in some way associated with them. So that's a development, for example, in Cayman that's been adopted there. Just on the rules themselves, interestingly enough, there's a wider range of choice in Cayman compared with England, even compared with England today, in a number of cases. In tort, the definition of tort is wider. It enables proceedings to be brought including breaches of duty under statute law or indeed inequity, which is not spelt out in the English rules. Trusts, our rules enable proceedings to be brought where there's a written trust instrument. But in Cayman, it can be not just written, but also express, implied, or constructive. But curiously, they don't have a rule permitting service out in a claim for a declaration that a contract does not exist, a head that does exist elsewhere. It exists here, it exists in Bermuda. Bermuda has that declaration of no contract, but has the narrower trust basis that stems from our 1999 rules. The East Caribbean Supreme Court rules have that same narrower tort head, they have the narrower trust head, but they do have the claim for no declaration. So there are variations, and it's certainly not right to say that one size fits all in the points of detail. Now, of course, these matter because many of these small jurisdictions are homes particularly to offshore companies and to trusts. Bermuda has a very well-established trust industry, and we know Cayman does as well. And therefore, it's not perhaps not surprising that more sophisticated rules have been adopted there to enable parties to be brought before the courts in these cases. Now, and I was interested to note, of course, there's one common thread, there are a number of common threads. One particular common thread I want to draw attention to is the thread that if the case concerns a contract and the parties have concluded a clause that confers jurisdiction on the chosen court, then that's a basis upon which service out of the jurisdiction will be permitted, a forum selection clause. And I was interested to hear the Qatari principle that Barbara mentioned a moment ago, founding a statutory jurisdictional basis to enable effect to be given to a forum selection clause. I'm not going to take time to talk about recognition and enforcement because that will be familiar to all of you. One point of difference may be the extent to which non-money judgments can be recognised and enforced. I did a case in the Cayman Islands some years ago where it was established where it was held obiter that non-money judgments would be susceptible to recognition and enforcement under the common law of Cayman, but that what would not be recognised and enforced is the role of a receiver that had been appointed by way of an interim measure in aid of Morava relief. That's it being said that the appropriate step to take is to apply to the Cayman court for a Cayman receiver rather than recognising extraterritorial power in a receiver appointed elsewhere. So that was an interesting wrinkle. Now, what I just wanted to do briefly, because it may be of interest to those of you from smaller jurisdictions, is to mention the Hague Convention on Choice of Court Agreements. This was concluded in 2005. I know we have at least one Mexican lawyer here, and Mexico was the first state to ratify this convention. It's since been ratified by one regional economic integration organization, which is otherwise known as the EU, on behalf of the member states. And it is thought that Singapore is coming close to ratifying it. It has signed it. A bit like Gary was talking about this morning about the 50-year history of the New York Convention on Arbitration. I think the ambition of the Hague Conference is that this convention will have a slow spread around the world, and in due course that parties will become members of it. If you choose to go the arbitral route, as Gary was urging us all to do, that's fine. But if you choose to subject your disputes to court-based dispute resolution, perhaps in one of these new specialist jurisdictions, if you're a company based in one of these countries, then it may be useful to you to know that your clause will be not only accorded recognition and given effect to, but that the judgment to which it gives effect will then be recognised and enforced in all the other member states, which is the key point. The development of this convention grew from the thinking that had led 50 years earlier, or 40 years earlier, to the Brussels Convention on Jurisdiction and Judgments within the European context, and which still, in a more sophisticated and slightly different legislative form, now governs all jurisdiction within the European Union. But the idea of it is that if you have common rules of jurisdiction, not indirect rules that come up for assessment on the recognition and enforcement stage, but direct rules of jurisdiction, that will then lead to much more automatic recognition and enforcement at that stage if all the courts are applying the same jurisdictional rules. And so I don't propose to go through it in a tedious way, but just to give you some of the key features of this thing, it governs exclusive choice of court agreements in civil or commercial matters in disputes between businesses. It doesn't cover what's called in the jargon B2C, businesses to consumers. It's B2B, businesses to businesses. There are a list of subject matter exceptions, which are the usual suspects, such as personal status and family law. It also excludes, interestingly enough, intellectual property rights, or at least disputes as to the validity of intellectual property rights, and it excludes arbitration, and then they've added some rather wise words, and related proceedings, thereby dodging some of the issues that have plagued that topic in the European context. The agreement must be in writing or, and this is important, documented by any other means of communication which renders information accessible so as to be usable for subsequent reference. You can see the drafter sitting there, can't you, thinking, how on earth can I make this future-proof in the internet age?
Twitter, Alex?
Twitter? Well, Twitter, I dare say, can be used for subsequent reference if you take a screenshot of it at the relevant time, which you would be wise to do. Article 5 confers jurisdiction on the chosen court, and importantly, this jurisdiction is not then to be undermined by a forum non-conveniens stay. Article 6 requires non-chosen courts to decline jurisdiction. So that gives effect to the exclusive nature of this jurisdiction and works against the risk of parallel proceedings. Article 8 provides for the more or less automatic recognition and enforcement subject to the grounds of refusal, and then there are grounds of refusal. Interestingly enough, those grounds of refusal are the nullity under the law of the chosen court. So at the recognition stage, you do have, to some extent, a review of the original court's jurisdiction, because the state addressed will be examining the application by the chosen court of the chosen court's law, if somebody's bold enough to take the point. But that sounds like a recipe for the lawyers to have fun. But unfortunately, the fun is somewhat undermined because there's a proviso, and the proviso says, unless the chosen court has held the clause to be valid, in which case the state address is stuck with it. And then other grounds of refusal, like capacity and incompatibility, and so forth. And there's power, interestingly again, to recognise only part of damages awards, and to refuse recognition, either in wholly or in part, to non-compensatory damages. This is the fear of triple damages under the Sherman Act and things of that sort. They don't want those enforced. So as I say, so far Mexico, EU and Singapore, it may well be that small states who are trying to promote the opportunities that their companies and trusts have to pursue litigation abroad will be attracted by this, but more particularly they may be attracted by the idea that by selecting their own jurisdiction, these companies would be effectively precluding other states from exercising jurisdiction over them. And that may be a selling point. Barbara mentioned earlier how forum shopping is something that used to be frowned upon but is now not. She then engaged in a process of forum marketing, and it may well be that small states would like to use the Hague Convention as a means of marketing their own forums in fora in due course. Thank you very much.
Alex, thank you very much indeed. You do remind me of the endless good fun of litigating all over the world, which for about 30-odd years I did as well before I laid it down in the interests of becoming a mediator. So I happily leave all of the interesting good fun that I'm reminded of to others. Because of the delightful lunch we were offered, we're running a little bit behind time, so if you don't mind moving straight on to the next panel of 3 speakers onto arbitration. Thank you very much indeed for this panel. There'll be an opportunity for commentators to ask you questions later on. Thank you very much.